You're watching The Legal Breakdown. So, Glenn, I am getting inundated with this question more than any other question. If Donald Trump is sentenced to prison, but he appeals, will he have to begin serving his sentence immediately, or will that sentence be stayed pending appeal?
You know, Brian, there's no definitive answer, but let's talk our viewers through the two likely possibilities here. Generally, when a defendant is convicted by a jury, sentenced by a judge, the next words out of the judge's mouth are typically, "Marshals, step him back," which means take him into custody so he can begin serving his sentence. Now, in white-collar cases, that doesn't always happen. Sometimes white-collar defendants, because, we treat them much better than the run-of-the-mill defendants who don't have power, privilege, influence, status, they're allowed to go home and do what? Get their affairs in order. Well, isn't that lovely for them? So Judge Merchan can do one of two things. First of all, I believe he will impose a sentence of incarceration, and we've talked before, and perhaps we'll talk again as his July 11th sentencing date approaches about why that is my view. But once he imposes the sentence, Judge Merchan can say, and I hope he does, "Marshals, step him back, take him into custody. It's time for him to begin serving his sentence of incarceration." But if Judge Merchan declines to do that, he can say, "I will stay the requirement that you begin serving this sentence right here and right now while you appeal your conviction." Let's hope he doesn't do that, but Judge Merchan can do it. He has the authority to do it. Let's assume he doesn't. Let's assume he says, "Marshal, step him back." And then Donald Trump will immediately file an emergency request with the appeals court in New York asking that they order his sentence of incarceration to be stayed or paused pending appeal, and then it will be up to the appeals court to deal with that. But here's why I started with there's no definitive answer. We have a concrete example in this age of January 6th crimes and criminals of why this question is unanswerable. We have two defendants, Brian, in Steve Bannon and Peter Navarro. They committed the identical crimes, 2 counts of contempt of Congress by thumbing their nose at congressional subpoenas. They went through nearly identical trials. They were both convicted, each of them by different juries in a New York minute. And then they were each sentenced to the identical period of incarceration, 4 months. Well, guess what? One was ordered to begin serving his sentence and is serving his sentence right now as we speak. Peter Navarro, the other, under identical circumstances. Steve Bannon was never ordered into confinement, and he got to appeal his case, and he's lost his appeal, and he is still at liberty. He has yet to see the inside of a federal prison. Same defendant, same crimes, same sentence, same circumstances, dramatically different outcomes. Why? What a difference a judge makes. One judge, the one that ordered Peter Navarro to begin serving his sentence, is a good, thoughtful, solid, respectable, fair, impartial, and independent jurist by the name of Amit Mehta. He happened to be a public defender in the courts back when I was a homicide prosecutor in the courts of Washington, D.C., and he ordered Navarro into prison. The other one, Trump-appointed Judge Carl Nichols, who has done Steve Bannon a solid. Steve Bannon hasn't seen the inside of a prison yet. What a difference a judge makes.
Now, you had alluded to this. If Judge Merchan sentences Trump to prison, Trump wants to appeal. Judge Merchan says that he'll still be incarcerated pending appeal. And then, of course, Trump is going to file an emergency motion or an emergency appeal with a higher court. Donald Trump has been talking all this time, and all of his mouthpieces have discussed all this time about the possibility of the Supreme Court swooping in to save him. Can you speak on that? Because they seem to be very bought in on this idea that the Supreme Court is going to, come and help Trump at the end of the day.
Brian, I think on the incarceration issue, which is a subset of the battles to be fought as Donald Trump tries to appeal his New York State criminal conviction, I don't think the Supreme Court has a basis to weigh in on that. The nature of the sentence imposed by a state court judge, as long as it's not illegal, in other words, it doesn't exceed the statutory maximum punishment, which this certainly will not, The question of a state court sentence and whether it should begin being served pending appeal or not is not an issue that I think the Supreme Court even has the lawful authority, the constitutional authority to weigh in on. But of course, the next logical question is, when has this Supreme Court been bound by the Constitution?
Well, let me ask you this. Would it be possible for them to say that they're going to take up the issue and stay any sentencing pending their, decision to take it up, in the same way that they really don't have any basis to take up this question of presidential immunity, which is the question in the D.C. case, but they're going to take it up anyway, knowing that it's probably not going to go anywhere, because we're talking about whether or not the Constitution allows for somebody to commit criminal acts while in office, as if that's part of their presidential oath. But it's the delay that Donald Trump is seeking, and it's the delay that the Supreme Court is going to give him. So in the same way, can the Supreme Court take up this issue, knowing that they don't have any jurisdiction over it, but just allowing him the delay might be all that Donald Trump needs at the end of the day?
Yeah, I'm becoming concerned because you're asking questions like lawyers ask. And I don't know, maybe we've been doing this too long at this point, but it's a great question. Here's the thing. When you say that, the Supreme Court doesn't really have any authority or any reason to take up the absolute presidential immunity issue, I agree with you 1,000%. However, they do have the jurisdiction to take it up. So they're not acting unethically or in an unlawful way by saying, listen, we have some interest in this issue as a constitutional matter, and we're granting review, and that's why everything in the trial court must come to a grinding halt. That's why Donald Trump will not be brought to trial in D.C. for trying to overturn the results of the presidential election unless and until the Supreme Court returns the case to Judge Tanya Chutkan, the presiding judge in D.C. So it's wrong as a matter of fact and law and constitutional precedent because there's no winning issue, but they have every right to grant review and take it up if they believe it is of enough constitutional interest to them. So I think that is a slightly different circumstance than whether they actually have the lawful authority to take up the question of a state court imposing a sentence and deciding whether that sentence should commence or whether it should be stopped or paused or stayed pending appeal. So now let me go to where we always end up when we're talking with the Supreme Court. Guess what? There is no authority above the Supreme Court that can call them out on their unlawful, unconstitutional, or unethical behavior. So if they want to grant review of a state court sentencing matter, whether a state court sentence should commence or be stayed, even if they have no constitutional reason or authority to do it, guess what? They're going to do it anyway, and no one can stop them.
Can you talk about the difference in terms of Trump appealing the verdict in this case or appealing the sentence in this case? Can he do both? Can he appeal both up to higher courts? Does it make any difference?
So he can seek an emergency stay of the sentence, say, look, I'm not arguing that it's unlawful, but I just don't think I should begin serving a sentence of incarceration because I have so many meritorious issues to attack the underlying conviction that led to that sentence. So he can appeal that on an emergency basis, but he can, of course, also appeal the conviction in its entirety, arguing that, Judge Merchan made this evidentiary ruling incorrectly and violated my rights in this way. And, that's what litigants do when they lose a case. They're sentenced. Then they batch up all of their complaints on appeal and they present it in one unified appeal to the appeals court. So he can do both things. They'll be done on a slightly different timetable. And, one is really a substance-based attack, which would be an attack on the conviction itself. And the other would almost be sort of a procedural or an equitable argument. Hey, don't make me start my jail term because I think I have winning issues attacking my conviction in its entirety. But if I begin serving a sentence, it's kind of like the horse is out of the barn. I'm already being punished when I maintain I shouldn't be punished in the first place because my conviction should be overturned.
Now, let's finish off with this. I know that we've gotten used to the dilatory tactics, the delay tactics of Judge Bannon, of Samuel Alito, Clarence Thomas, the rest of these Republicans on the Supreme Court. If we want swift accountability, what does that look like in terms of the New York verdict being appealed. Can we see, for example, if Donald Trump wants to file an emergency appeal to a higher court in New York from Judge Merchan to a higher court, what would it look like? Could we see the higher court, the appeals court in New York, rule on that within like a couple of days and swat it down, basically? Like, would that be what swift accountability looks like?
In my opinion, Brian, swift accountability looks like Donald Trump being forced to begin serving his sentence, as would almost any other criminal litigant, as soon as it's imposed by Judge Merchan, particularly if it's a sentence to incarceration. That is swift accountability, because then while he's serving his sentence, he can take all the time he wants litigating it up through the appeals courts in New York and try to get it reviewed by the Supreme Court. But the sentence should commence after he is sentenced, because that's what accountability and punishment looks like in the vast majority of criminal cases. What I don't think will happen is the appeals courts in New York will set his substantive appeal, attacking his conviction, on some kind of a crazy accelerated track where they're deciding things in days and weeks, and it's, moving right through the system. I don't see that happening. I hope when he is sentenced to incarceration, Judge Merchan does what's right, I think, for the country, to punish Donald Trump for his 34 felony convictions. These are convictions that he earned as a result of the crimes he committed to try to steal the 2016 presidential election. And let's not forget, during the pendency of this case, he also committed 10 other crimes and was found guilty beyond a reasonable doubt by Judge Merchan of 10 counts of criminal contempt of court, and he should also be punished for those.
Well said. We will, of course, stay on top of all of this as this process continues to play itself out. I hope that working through these thought experiments a little bit answers some of the questions that the viewers have had. And, of course, if you have more questions, feel free to reach out, to leave them as comments, or to shoot us messages. We'll always try to answer those questions the best we can. And, of course, to see subsequent episodes where we do exactly that, please make sure to subscribe. Glenn is well on his way to 1 million subscribers. I'm on my way to 3 million. If you are not yet subscribed, we'd really appreciate it if you could subscribe to both of our channels. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.